Okay. And as best you can recall, when did you make this agreement?
Right, I mean, it all was right around the time of his loss. When we did the agreement, I know the title, I can't remember exact dates, but that Saturday when we lost him, we swapped titles that Thursday
Okay.
before that Saturday, whatever the date was, I can't recall.
And on that Thursday, did you swap the vehicles as well?
Well, he already had, we swapped the vehicles maybe 2 days earlier to that, but we just never got a chance to actually pull the titles out and sign over titles.
Okay. Were any plans made to sort of finalize this agreement?
Yes. That Monday coming, we were going to go to the DMV and get, everything swapped over, the Mercedes into his name and the Blazer into my name.
So you had plans the Monday following Mr. Scott's death to go
Yes.
to DMV?
Yes.
Okay. Do you recall from memory the license plate of your Mercedes tag number?
Not exactly, so long.
If you heard the tag number, do you think that would refresh your recollection?
Good.
1318GG, does that sound like it?
I remember it sounds familiar, yes.
Okay. So by the weekend of Walter's death, he was driving the Mercedes and you were driving the Blazer?
Yes, well, I had it because I still had to do some work to it, but he was already driving the Mercedes, yes.
I should go ahead and mention, how did that deal work out with you with the Blazer?
Worst thing I wish I let him keep his Blazer. That Blazer was a piece of trash.
Mr. Mayor, let's take you to that Saturday. Do you recall hearing about what had happened to Mr. Scott?
Yes.
And how did you hear about that?
My neighbor across the street, the girlfriend, Miss Charlotte, she came knocking on the door saying that something had happened to Walter. So I gave her a ride to Remote Road where it happened, and that's how I heard about it and got to the scene and stuff.
So you went to the scene that day?
Yes.
And you took Miss Robinson with you?
Yes.
Charlotte?
Miss Robinson, yeah, Charlotte.
Did you ever see Walter that day?
No.
Did you ever again see Mr. Scott?
No.
Court's indulgent. Did you ever get the $300 that were?
No, actually, I owed him $300.
Okay. Mr. Hayward, please answer any questions the defense has for you.
Okay.
Thank you, of course.
Any questions by the defense?
Please support.
Yes, sir.
Good morning, Mr. Haley. As I understand your testimony this morning, your knowledge of the facts and circumstances of this case are confined to the vehicle that was stopped that morning of April 4th. Is that correct?
Yes, sir.
And as I understand your testimony, that the vehicle in question, was it still owned by you, or,
Yes, sir.
and did you have insurance on it at
Yes.
that time?
Yes, sir.
With Geico?
Yes, sir. Correct.
And did Mr. Scott, did you inform him that the car was insured?
Yes, sir.
And did you provide him with the information regarding the insurance?
Yes, sir. Everything was actually in the car.
It was in the glove
Compartment. Yes, sir.
You know that it was in the glove compartment?
Yes, sir.
No question about that.
Well, once again, I have a 2-year son. We, right before I informed him that I was going to sell the car to Mr. Scott, I had him to take out anything that might have been having on the inside of the car that belonged to me or him, because he have drove the car too. And I wouldn't say he knew better than to remove any insurance information or anything, because that's something I will explain to him. So I wouldn't say 100%, being a teenage son, but yes, it should have been in here.
So there would be no reason if the driver of the vehicle was asked for the insurance and suggested looking in the glove compartment, the driver of the vehicle not to do that.
Should be no reason.
The vehicle, the Mercedes, was in good operating order,
Yes, sir.
and you had indicated that you checked that before turning it over to Mr. Scott.
Yes, sir.
And at the time that you turned it over, you checked the lights as well,
Yes, sir.
that they were all operating
Yes,
correctly.
yes, sir.
The vehicle, when it was, after the 4th of April, was it returned to you?
Repeat it.
After the incident in which Mr. Scott lost his life, was the vehicle ever returned to you?
Oh, no, sir. No, sir.
And the vehicle paperwork was done sometime after the death of Mr. Scott?
Well, the family, I explained to the family that, me and Mr. Scott have already, did the paperwork, signed it over. It wasn't, I guess by law, we never made it to the DMV, but by right, it belongs to him. It's still, I guess you would say the title, being that he never got it registered, the car is still in my name, but it belongs to him.
Now, all the paperwork was done prior to the 4th of April.
Yes, just a signature.
And then the government's involvement was after the 4th of April.
I guess so.
Sure about that box, not the glove box?
Glove box? I hope. Yeah, that's weird.
In all the times that Mr. Scott had used your car, that's where the insurance car was getting.
Yes, sir.
Thanks.
Anything further?
Just briefly, Your Honor. So, while you used the car, you kept the insurance card to the glove box. And when you're saying when Mr. Scott would use it periodically, that's where it would remain?
Yes.
But other than that, you don't know
No.
where it would. And since we've been talking so much about this car, may I approach the witness, Your Honor? Showing you what's been marked for ID only is states 66 and 67. Take a minute, look at that. And what do those photographs depict?
What do you?
Is the vehicle we're discussing?
Yes, yes.
Photographs. that fair and accurate depictions of your car as it appeared when you exchanged it with Mr. Scott?
Yes, it is.
Okay. All right, this time the state would move to enter 66 and 67 into evidence and publish for the jury.
Objection.
No objection.
They're admitted.
Judge, I'll just show it. Oh, yeah. It's 66 and 67. Nothing further, Your Honor.
Anything further?
Nothing.
Thank you. Step down.
Judge, may we approach?
Yes. Back at 1:45. I'm ready for lunch. 1:45. Please do not discuss. Everyone in the courtroom, be seated. As an additional ground for the court's ruling regarding the matter that was taken up outside the presence of the jury, it's firmly established that inadmissible evidence may be properly admitted when opposing counsel opens the door to that evidence. And whether the door is opened through conduct or questioning of opposing counsel is left to the sound discretion of the court in the instance, in addition to the court's ruling of the evidence being irrelevant and improper character evidence regarding the victim. The state did not open the door. The defense, through its own solicitation of witness questions, question to the witness, cannot create an open door situation in the manner sought in this case. So that's an additional basis for the court sustaining the state's objection. It will be in recess until 1:45.
Sure.